Hi everyone, very good afternoon and welcome back to CGP Mentors. So in this particular class, we will be starting with your marathon for module D and that is for paper number 4, right? So let us start that. Number one question that we have is, as per Indian Contract Act, which of the following is true regarding the return of goods in a bailment contract, right? So over here, the correct option is goods can be returned after being transformed as long as they are identifiable. So as per the definition of bailment, goods must be returned once the purpose is accomplished, even if the goods is changed in form, like for example, cloth has been tailored into a suit. As long as they are identifiable and traceable to the original goods, you can do so. Now, which of the following statement is true regarding the termination of bailment as per section 153 of the Indian Contract Act? So, the bailer can terminate the bailment if the bailee misuses the goods. So, section 153 allows the bailer to terminate the bailment if the bailee uses the goods in a manner not agreed upon. If that is the case, then it can be terminated. What is the standard of care required by the bailee? What kind of standard of care is required? It should be equivalent to a care that a prudent person will take care of his own goods, right? So, if I have taken goods from somebody, I have to take care of the goods in a similar manner as if the goods belong to me. Next is, what right does a bailee have under section 170 if they have provided a service related to the bailed good? So, what kind of right that they are having? Right to retain the goods until paid, right? So, they are having this right to retain the goods until they are paid. It is said that section 170 grants a particular lien to the bailee who has used skill or labor to improve the bailed goods. If the payment is not made for the services, bailee has the legal right to retain the goods until payment is received. Now, under section 163, what must the bailee do with an increase or profit from the bailed goods? So, it has to be given to the bailer. आपको ये bailor को दे देना है if there is any kind of increase or profit from the bailed goods. Next, we have, if the proceeds of the sale of the pledged goods exceed the amount due, what does the pawnee do as per section 176? So, अगर ऐसा exceed होता है, so in that case return the surplus to the pawner. ठीक है, आपको surplus जो है वो pawner को result वापस दे देना है. Just a second. Next, we have, in case of default by the pawner, what actions can the pawnee take as per section 176? So, the pawnee can bring a suit or the case against the pawner and retain the goods as collateral security. This can be done. Now, as per section 182 of the Indian Contract Act, who among the following can act as agent? कौन agent बन सकता है? So, a person who is authorized to represent another in the dealings with the third party, that person is authorized to act as an agent. Now, which principle states that whatever a person can do personally shall also be allowed to be done through an agent? This principle is called as principle of representation. That means one person can represent you. Next is, under section 187 of the Indian Contract Act, which of the following types of authority allows an agent to infer their power from usual way of doing the business? So, it is implied authority with the agent to do the task which has been instructed to him. Next, under section 193 of the Indian Contract Act, what is the principle of liability? If an agent appoints a sub-agent without proper authority, if it has been appointed without proper authority, principal is not represented by or responsible for the sub-agent action because principal was not consulted enough. Now, under section 163, what must the bailee do with an increase or profit of the bailed goods? That we have already seen, give it to the bailer. A universal agent is characterized by how? Authority to act on behalf of the principal in all matters. This is what the characteristic of universal agent is. Which of the following is not a duty of an agent towards the principal? क्या duty नहीं है? So, duty to be indemnified for lawful act. This is not the duty. Now, under section 222 of Indian Contract Act, an agent is entitled to be indemnified when he acts lawfully and within his authority. ठीक है, तो कब indemnify करना पड़ेगा? If he has fulfilled all his duty he has acted lawfully and within his authority. If that has been the case, then he should be indemnified. Now, under what condition is the principal obligated to indemnify an agent against the consequences of lawful acts? When the agent has acted within the authority. Which of the following is not a valid scenario for principal's obligation to indemnify an agent? If the agent engages in the criminal activities, right? So, that is not a valid scenario for principal's obligation. As per section 237, when is a principal bound by the unauthorized act? कब unauthorized act के through भी bound रहेंगे? If the principal words or conduct induce third party to believe that the acts were authorized, right? If the agent in front of you was telling something to the third party which he was not authorized for, and still you did not raise any kind of what you can say obstruction to it, right? You did not raise any kind of red flag, so you will remain responsible towards the third party. Now, as per the Indian Partnership Act 1932, what is the maximum number of the partners which are allowed in the partnership, right? So, over here the correct answer is 50. Now, which of the following is not a characteristic of general partnership? So, firm must be registered. This is not the characteristic because registration of the partnership is not mandatory. Next is, in a limited partnership, which of the following statement is true regarding the liability of a limited partner? So, limited liability to the amount of capital contributed, right? Over here the correct answer is liability is limited because the partnership is a limited kind of thing where normally partnership is unlimited, but in case of a limited partnership you are only responsible for the amount that has been contributed by you. Now, which of the following rights is available to an unregistered partnership firm? So, right to sue for the dissolution or settlement of accounts after dissolution. So, that is available. An unregistered partnership firm, it has got limited right. It cannot sue the third parties or partners to enforce the contractual rights, but still the Indian Partnership Act permits the firm to sue for the dissolution of accounts and for realizing the property. This can be done even if you are unregistered. A minor who is admitted to the benefits of partnership has which of the following rights? क्या rights होते हैं minor के पास? So, he has the right to inspect and copy books of accounts. He can see that. On retirement of a partner, the firm fails to give public notice. Now, which of the following is true? The retired partner will continue to be liable to the third parties. Why? Because third parties did not know that the partner has ceased to be a partner in the partnership firm, right? So, if you have failed to give the public notice, that is the liability that you will be having. As per section 12, a stipulation in a contract of sale with reference to goods can be classified as condition or warranty, right? It depends on whether it is essential to the contract or it is collateral to the main purpose. But if there has been a term that is given, we will call it as a condition of warranty. When can a breach of condition be treated as a breach of warranty? So, when the buyer waives the condition and opts to claim the damages instead, even though the condition was very core to the contract, but still buyer is like, okay fine, you just give me the damages, right? So, in that particular case, the breach of condition can be treated as breach of warranty. As for section 13, if the sale contract includes a condition that the seller must fulfill, buyer can choose to either waive the condition or treat it as a breach of warranty. That depends on buyer. What condition applies to goods sold by description? So, if you have sold something like this pen is very nice, this writes very smoothly, you have given a brief description about it. So, your description must match the goods. That is very, very important. Next, in a sale of goods by sample, what is implied under sale of goods? So, bulk must correspond with the sample in quality. Okay? So, if I have shown you one sample, the rest of the bulk should also match with the sample. Now, when does the property in goods pass to the buyer in a sale of specific goods in a deliverable state? So, when the contract is made unless a different intention appears. Under the sale of goods, who is the unpaid seller to whom the whole price has not been made or paid or tendered? That means you have not paid the whole price, that person will be called as unpaid seller. Next, which of the following is a right of an unpaid seller against the goods? So, he has got the right to lend until unless I am not receiving the full money for my goods delivered, I am not going to give the goods to you if they are in my possession. What is meant by future goods? Future goods means the goods which are yet to be manufactured, produced or acquired by the seller. I am doing the contract with you, but the goods for which I am doing the contract, I do not have the possession for the same. Those are future goods. According to Sale of Goods Act, what does the term mercantile agent means? Mercantile agent का मतलब क्या होता है? Over here, it is an agent having in customary course of business the authority to sell the goods, consign the goods, buy the goods or raise the money. This is the general function of an agent. So that's the person we will call as mercantile agent. As per sale of goods, which statement is true regarding the transfer of ownership in a sale? So both ownership and possession have to be transferred. आप ownership भी transfer करेंगे and possession also you will transfer when you are transferring the property. What is the key element required for agreement to sell to convert under the sale? So fulfillment of the conditions or the arrival of future date. If the conditions have been fulfilled, then the agreement to sell will be converted into a sale agreement. Right, that means the sale will be completed. Now, which of the following statement best describes a valid contract under the Indian Contract Act? So, it's an agreement which is made with the free consent of the competent parties. Note the free consent, note the lawful consideration and the object. Now, under the Indian Contract Act, which of the following situations would result in contract being considered voidable? Voidable means it is not valid if one party stands against it, right? So, in that particular case, if the consent has been obtained through undue influence or coercion, in that particular case, it will be considered as a voidable contract, right? Now, just a second, give me a moment. Okay. Moving forward, what is the primary obligation of partners towards each other? क्या है? So, primary obligation towards each other is that they shall carry out the business for mutual benefit of each other, and they bind the partners from the action of their what you can say business transactions. Now, agreements in the restraint of trade are considered valid. ठीक है? Agreement in the restraint of trade, they are considered valid if they are reasonable in terms of time as well as the geography. Next is in the case of firm constituted for a fixed term continuing business after the expiry of that term, what happens to the mutual rights and duties? We formulated a firm for a period of 1 year, but we are continuing beyond that also. So, your rights and duties of the partners will remain the same, okay, for the entire duration as they were before the expiry. Now, in a contract of guarantee, who is the party to whom guarantee is offered? So, guarantee is offered to the creditor who has given the money, that if you will not receive your money, we are going to pay to you. That is a contract of guarantee. Which party in a contract of guarantee is responsible for fulfilling the obligations? If the principal debtor defaults, right? So, agar principal debtor, the person who was supposed to pay the money to the creditor defaults, then the surety will pay the liability. ठीक है? The person who has given the guarantee. As per section 128 of the Indian Contract Act, when does the liability of the surety arises? कब arise होगी? So, only when the principal debtor fails to pay the debt. Only then the liability is going to arise. How can a continuing guarantee be revoked by the surety? By giving notice to the creditor of revocation. That means right now you have given the guarantee, but you do not want to be associated with the guarantee any longer. So, you will give the notice to the creditor that I am not giving you the guarantee any longer, and our transaction is cancelled. Now, as per section 133 of Indian Contract Act, what action discharges the surety as to transactions subsequent to the variance? So, if there are any changes, variance in terms of contract between the principal debtor and creditor. See, the main parties, they have changed the conditions among themselves and they have not informed surety, or if the surety is not happy with it, then then in that particular case it will discharge the surety. That means surety will no longer be responsible for that. Now, as per section 135 of the Indian Contract Act, what actions by the creditor discharge the surety unless the surety assents? So, these are all the features. Making a composition with principal debtor, promising to give time, agreeing to not sue the principal debtor. So, all these are against the surety consent. What type of act by the creditor discharges the surety? So, if any act that has been done inconsistent with the right of surety, then the surety will say that I am not responsible to be fulfilling the guarantee for you. right? Now as per section 141 of the Indian Contract Act, what is the right of surety regarding the creditor's security? So what is the right of surety? Entitled to benefit of every security held by the creditor. Now what happens if the creditor loses or parts with the security without the consent of surety? If that is the case, then obviously surety's liability is reduced by the value of lost security. If you have lost the security, then this person, innocent person who has given the guarantee, is not responsible for you. Which of the following statement best describes the parties involved in the contract of indemnity? So there are two parties, okay, promisor as well as the promisee in case of contract of indemnity. What is the legal position of a contract of indemnity? That is implied rather than expressly stated, right? So क्या implied है? It is valid if it can be inferred from the conduct or facts. अगर आपके conduct से पता चल रहा है, then also it is valid and we call it as the implied indemnity. ठीक है? What are the rights of an indemnified person? Indemnity का मतलब क्या होता है? Making good the loss that you will incur. So what are the rights of the indemnified person under the Indian Contract Act? Right to recover the damages, cost and compromising sums. Now as per the judicial interpretation, when can indemnified be sued for specific performance? Ki now you have to indemnify when the absolute liability has been incurred. When I have incurred the loss, obviously I will call upon the company, for example insurance company, that come and make good my loss, right? Then under the Indian Sale of Goods Act, which of the following condition does not deem a seller to be an unpaid seller? So in that particular case, the seller agrees to extend the credit period. अगर आपने credit period extend करने के लिए हाँ कह दिया है, then in that case you will not be considered as an unpaid seller, right? What type of lien does an unpaid seller has as per the Indian Sale of Goods? So it is called as possessory lien. Possessory lien means you will have the possession of the goods until and unless the price is paid to you. If a buyer wrongfully neglects or refuses to accept or pay for the goods, what is the remedy available to the seller? So he can sue the buyer for the damages of the non-acceptance. Next, under section 61, what can a seller claim if there is specific agreement with the buyer regarding the interest on the price of goods? So in that case, section 61 permits the seller to recover interest on price if contractually agreed, also if he remains unpaid, right? What is the unpaid seller's right of stoppage in transit extinguished under sale of goods when the buyer takes the delivery? Obviously, if the buyer already has the possession of goods, how you can stop in transit? So that your transit related right would be stopped. Now, under what circumstances unpaid seller resell the goods without giving notice to the buyer? So, if the goods are perishable in nature, right, they can be destroyed if the time taken would be too much. So, in that case, the seller can sell the goods, right. Now, if the unpaid seller sells the good again after giving proper notice and there is a deficiency in the resale price, what right does the seller have? So, recover deficiency from the buyer, that can be done by the seller. Now, when can a buyer recover the price paid along with the interest? So, when consideration has failed due to breach. So, in that case, the buyer can recover the price. Which of the following is not a feature of company under the Companies Act? So, a key feature is that company is having the limited liability. So, obviously unlimited liability is not going to be the feature. Which of the following companies is formed under special act of parliament? So, statutory companies, these are created by law and hence called by the companies statutory companies. Which type of companies has liability of members limited by guarantee? So, such companies we call as company limited by guarantee, where the members liability is limited to the amount they agree that they will contribute if the company is going to be wind up. So, these are called as company limited by guarantee. What is the primary objectives of MOA? MOA का primary objective क्या है? Defining the company's constitution as well as the scope. So, it talks about the objectives, it talks about the place that where you are situated, it talks about who are the subscribers to the memorandum, right? It talks about the liability that you are having, all these things. The document that governs the internal management of the company, we call it as the Article of Association. Now, what is the legal implication of the doctrine of ultra vires? Ultra vires means the act is void and it cannot be ratified. I have given you 5 powers, right? And if you do something which is outside of those 5 powers, and then that act would be called as the ultra virus. Now what is the objective of doctrine of indoor management? Doctrine of indoor management is protects the outsiders dealing in the good faith, because you are not supposed to know what is happening within the company. So this doctrine protects you. Now who among the following can become the member of company? So a minor and a company, yes, both can become, right. Partnership firm does not have a legal what you can say applicability or legal existence of its own. It depends on the identity of the member, so hence it cannot become. But a minor and a company can become the member. Which of the following does not result in cessation of membership? So if the director identification number has expired, it does not result, it is not related to the members of or shareholders, right. So minimum number of directors in a public company has to be 3, कम से कम 3 directors होने चाहिए. Under which form must a director give consent to the company before acting? So DIR2, that is the form in which the consent has to be given. Now which of the following is a key distinction between company and a partnership? क्या key distinction है? So over here a company has a perpetual succession where the partnership is dissolved with the death or retirement of the partner. A holding company is one which controls the composition of the board more than 51%. If the company holds 100% share capital of the other company, it would be called as a holding and wholly owned subsidiary relationship. If a company holds more than 51% of the ownership of a company, it will be called as holding subsidiary relationship. Now which of the following is not a clause of the memorandum of association? So this is called as the audit clause. Right, it is not in MOA. Name clause is there, capital clause is there, object clause is there, but the audit clause is not there. What is the effect of doctrine of constructive notice? So doctrine of constructive notice tells it protects the companies by assuming all persons dealing with the company have knowledge of public document. That means if I have issued a prospectus, I am hoping that you all know about the prospectus. Now which of the following cannot be treated as member of company? So partnership firm obviously cannot be treated as member of company. As per Companies Act, register of members should be maintained at registered office or any other place. What is the minimum subscription required under the Companies Act? So that is 90% for a public issue. Then what is the lock-in period for sweat equity share for employees? This is 3 years. 3 साल का आपका lock-in period होना चाहिए. In a public company, at least half of the directors are liable to retire by rotation, right? So who is appointed through form DIR3? So director identification number applicant, right, DIN applicant, he is appointed through form DIR3. So maximum number of directorship a person can hold in all companies together, that is 20. A person can be director maximum up to 20 companies. Now what is the maximum number of companies a person can act as a director excluding the dormant companies? Dormant companies for be maximum 20. Now which form is used to notify the ROC of the director's appointment? So DIR12 is the form that we use for the intimation to the ROC that a director has been appointed. What is the maximum tenure of the alternate director under section 161? So till original director returns or AGM, annual general meeting of the company, whichever is earlier, an alternate director acts in the place of absent director. Now under section 184, which of the following must be disclosed by the director? So if he is interested in contracts or arrangement, he has to disclose it. Under section 185, the companies are prohibited from giving loans to the directors, right? So 185 restricts the loans to directors or loans to such entities in which the directors are interested. Now which of the following powers can only be exercised at a duly convened board meeting? So both B and C. Approval of dividend, making calls on share, right, those both can be approved. Now compensation for the loss of office to the directors is governed by section 191. Okay, which document is used by the company for making a public offer? So we call as red herring prospectus, where the price or number of shares of details is not mentioned. Red herring means it's an incomplete prospectus and it is used in the case of book building issue. Book building issue ke case mein we use it. Now 93, which of the following is not a person liable for the misstatement in the prospectus? So shareholder is not liable because it comes under the responsibility of promoters or directors. A person cannot claim protection under doctrine of indoor management if they are company's insiders. You know what is going on in the company, so you cannot have this protection. Now, which of the following directors is appointed by the board to fill a vacancy caused by death, resignation or disqualification? So, casual vacancy directors. What is the minimum number of independent directors? So, 1/3 of the board, it is required in the listed companies. A person shall not be appointed as director in more than how many public companies? So, you cannot be appointed as a director, only 10 can be in the public company out of the total 20. Now, the registrar of directors and key managerial personnel is required in the form MBP2. It is maintained in the form of MBP2. Who is liable to maintain the register of members and update changes therein? So, obviously the company is liable. And who among the following can inspect the register of members? So, any member can do it. So, these were all the questions that we had to discuss in the module number 4. I hope you will revise it well.